Good morning from London, and a very warm welcome to everybody who's watching this webinar on sanctions and specifically the control test. The aim of the webinar this morning is to analyze the recent judgments that have referred to this subject and look at the very timely guidance that's been issued by both the Foreign Office and OFSI on Friday of last week to gain a better understanding of what it means and to try to find a way of mapping the way forward. And we couldn't have a better panel to discuss this issue. Firstly, we have leading counsel Maya Lester KC from Brickcourt Chambers, widely regarded as the doyen of the sanctions bar. We also have Chloe Sina, who takes the lead for sanctions at Deutsche Bank, and few have done more to grapple with the sanctions challenges over the last 18 months or so in the financial sector than Chloe. We're delighted, particularly delighted, to have two senior officials from government. Daniel Drake. Daniel is the Deputy Director of the Sanctions Directorate at the Foreign Office, and he leads the charge for UK sanctions policy following Russia's invasion of Ukraine. And Beth Davis is one of the two Deputy Directors of OFSI, and as you all know, OFSI is the Treasury Department responsible for the policing and the enforcement of UK sanctions, as well as outreach to industry. So the plan is to talk about this subject for about 50 minutes or so. We'll try and find time to pick up a few questions towards the end of the session if we have time. We'll do our very best, because I know it's a subject of great interest, but we hope that we will cover most of the questions and issues that people will be concerned about. So firstly, can we just set the scene? Maya, can I turn to you and just ask you, first of all, what do we mean by the control test? And perhaps you could just summarize what's happened in the two recent judgments that have touched on this, the Court of Appeal judgment in Minsk and the very recent Commercial Court judgment in Litasco.
With pleasure. Thank you very much. So the control test in economic sanctions is extremely important because it determines who is subject to UK financial sanctions. So most of you listening will, of course, know this already, but economic sanctions apply not just to those on the list of companies and people that you will be screening, but also to entities who are not listed, but are owned or controlled by the people who are listed directly or indirectly. And UK sanctions have a very broad definition of what control means for those purposes. And what it says is that a designated person controls a company if it is reasonable to expect that the designated person would, if he chose to, be able to achieve the result that the affairs of the company are conducted in accordance with his wishes, having regard to all the circumstances, in most cases or in significant respects, by whatever means, whether directly or indirectly. Now, that is a very broad test, and it's also a very subjective test. And we're here today to discuss some of the problems it has given rise to. Now, that test doesn't apply just to Russia sanctions in the UK. It applies across the board to UK sanctions regimes. But the cases in which it has arisen recently for discussion have been Russia sanctions cases. So the two cases I just very briefly wanted to outline. First, the case of Mints. A claim was brought by the National Bank Trust and Bank Okrity against individuals, basically for a conspiracy to enter into transactions to replace loans with worthless bonds. And the Mints defendants to that claim applied for a stay of the proceedings on the grounds that Bank Okrity is designated as a sanctioned entity, and the National Bank Trust, the other claimant, is controlled, they say, by President Putin or by the governor of the Russian Central Bank, Ms. Nabiullina, who are both expressly designated on the UK sanctions list. The Court of Appeal said the main judgment is on how sanctions don't stop a designated person from bringing civil proceedings or the court from giving a money judgment in favor of a designated person, and therefore the stay application was rejected. But the court, very importantly, also made some comments, what lawyers called obiter dictum, in other words, not necessary to their judgment, but after full argument, about the issue of whether the National Bank Trust was controlled by President Putin or the governor of the central bank. The High Court had said that despite the very broad regulations definition of control, they shouldn't be interpreted as meaning that just because President Putin or the governor are in the position they're in, their political office, that they controlled public entities. And the Court of Appeal said that was impermissibly reading words into the regulation that are not there. The regulations are very broad. If they're too broad, that's a job not for courts to be putting a gloss on the words, but for the executive and parliament to amend. And if they said, importantly, the consequence of these broad regulations is that, in fact, every company in Russia were controlled by President Putin, because ultimately, in a command economy, it could be said that he controls them all, then the regulation should be amended. That caused a bit of a stir, and we will come on to discuss that. But very briefly, there's a subsequent case, this time a High Court judgment, also commenting on this issue. It's called Litasco. This was a claim by a subsidiary of Lukoil, not a state-owned company, a private company in Russia. The defendants had refused to make some payments to the Lukoil subsidiary on the grounds that Lukoil is sanctioned. And the judge, Mr. Justice Foxton, in that case, taking what could be described as a pragmatic view on what the Court of Appeal had said, disagreed to the extent that the court had suggested that reading of the regulations, and said he thought the regulations should not be read so broadly that President Putin was arguably in control of every company. And he said that test that I read out, that if it's reasonable to expect a designated person would, if he chose, be able to achieve the result that the company's affairs are conducted in accordance with his wishes, that doesn't cover a situation in which President Putin could ultimately place Litasco under de facto control, and in fact every company in Russia. He thought the test is concerned with the existing influence that a designated person can have over the affairs of the company. So we'll now come on to where all of this leaves us.
Well, thank you very much. Daniel, then can I just turn to you in relation to the FCDO? Very soon after the Minsk judgment, the FCDO put out very helpfully, in terms of timeliness, a statement. And that statement drew a distinction between public and private bodies. And you've then, that's been overtaken by guidance, joint guidance that was issued on Friday by both the FCDO and by OFSI. So can I just ask you, first of all, why was it felt necessary to put out both the statement and the guidance on Friday?
Thank you, Michael, and good morning. Good morning, everyone. It's great to have this opportunity to speak to you directly this morning. I think, Michael, in answer to that question, you will be very aware, and as Maya set out as well, that that really unprecedented scale and nature of the sanctions that we've imposed against Russia since its full scale of invasion of Ukraine last February. And we are certainly very aware that given the scale of those sanctions against both individuals and entities, and also the sectoral measures that we've been imposing with our partners, that inevitably raises some very complex questions around issues such as ownership and control, as Maya has set out. I think what I would draw you back to the very first sentence, actually, of the guidance that we put out on Friday, which is that the policy intention of HMG's approach to ownership and control in UK sanctions regulations is to ensure that sanctions cannot be easily circumvented. So where we do see these sort of judgments that are very important, I think, for the legal community, there's a need for some additional clarification from the government. Then of course this is the kind of thing that that we will respond to. And in the case both of the Minsk judgment and of the subsequent sort of consideration of this, we concluded that it was the appropriate thing to put out the more detailed guidance that you will have seen reach your inboxes at the end of last week.
Daniel, thank you for that. Can I just then turn to drill down a little bit into what the guidance from Friday actually says? So the first thing that it seems to do is it makes a distinction between private and public bodies. So just focusing on public bodies for a moment, the new guidance says that you will look to designate a public body where possible when designating a public official, if the FCDO considered that the relevant official was exercising control over the public body. So far, so good. So could those listening to this webinar, can our audience now assume, if they're dealing with a Russian public entity, that has not been specifically designated, despite the public official at the helm of that entity being designated, that the public body is not sanctioned. And let me just give you an example. When the FCDO designated President Putin and Foreign Minister Lavrov, it said that the sanctions were targeted personally at them. So does this guidance that you've issued mean that we can now assume that the FCDO thinks that the Russian Foreign Ministry isn't controlled by Sergei Lavrov?
Thanks, Michael. So the general position, as we set out in the guidance, is that FCDO does not generally consider designated public officials to exercise control over a public body in which they hold a leadership function, such as that the affairs of that public body should be considered to be conducted in accordance with the wishes of that individual. And that obviously is the test set out in Regulation 7.4, for example, of the Russia sanctions regulations. The reading from that, therefore, would be that we would not consider Foreign Minister Lavrov to, as it were, control the Russian Foreign Ministry within the meaning of the regulations, and therefore the ministry itself is not captured as a result of this designation. And the reason that we made that clear is as we set out in the guidance, that the FCDO does not intend for sanctions measures targeting public officials, for example, to prohibit the kind of routine transactions with public bodies that people may find themselves committed to, for example, payment of taxes, fees, import duties, and the other examples that we've set out in the guidance. However, as I'm sure my OFSI colleagues would also reiterate, of course, we continue to expect firms and individuals to fully consider the risks of an entity being owned or controlled. And as I set out, the objective of all of this is to ensure that sanctions cannot be easily circumvented, and that could include conducting your own research, requesting further information from the entity, and taking legal advice if you are unsure about your obligations. But the general position is indeed that we do not consider designated public officials to exercise control over a public body in which they hold that leadership function as defined in Regulation 7.4.
Okay, thank you. That's very helpful. I mean, I think sometimes it's very useful to have specific examples because they sort of draw out what the policy position might be. So could I just give you another one? So to OFSI's great credit, there's been lots of outreach with various industries, and in one aspect of outreach, there was a question asked about Rosatom, which is, the Russian Atomic Agency. We understand the position of the government is that Rosatom is not itself designated, even though all of the directors of Rosatom are specifically sanctioned. So can we assume, again, using that as an example, that applying your guidance, Rosatom itself is not sanctioned? And just as a sort of follow-up to that, the outreach is wonderful that OFSI engages in, but would it be possible in those circumstances where there are statements of that type that are made to industry bodies, whether those could be circulated a bit more widely and made more publicly known?
Thanks, Michael. So on your first question, that's essentially correct. We don't consider that the fact that the board members of Rosatom have been designated to mean that the entity is controlled within the meaning of the regulations. We have sanctioned a number of actors in relation to Rosatom, including subsidiaries and also, as you say, the board members. But we do not consider the Rosatom parent company, as it were, to be controlled within the meaning of the regulations. And that's very much in line with the position on public officials that we set out in the guidance. On your point about public statements, obviously the purpose of issuing this guidance on Friday was to make a sort of broad statement of our policy position on these important issues. I think we would need to consider very much on a case-by-case basis whether there would ever be a need for additional specific statements on specific cases. But the guidance that we issued on Friday was certainly designed to give that broad policy position. Thank you.
So just on public bodies then, can I just flag something where perhaps the guidance doesn't necessarily sit altogether neatly with what the regulation says? So the guidance in respect of public bodies currently says, it adds that even if the specific public body is not designated, if a designated person derives what's called a significant personal benefit from payments to that public body, such that they amount to payments to the person rather than to the body, then you might consider the control test has been met. That doesn't appear specifically in any of the regulations. And so how does that sit with your guidance that you will look to designate a public body where possible? If you could perhaps shed a little bit of light on that for us, we'd be very grateful.
Yes, I think what we were trying to do there, Michael, was to give, one or two sort of practical examples of the kind of considerations that the UK actors need to bear in mind when deciding whether the control test is met. So from that point of view, it was a practical sort of illustrative example as to whether Section 7.4 is engaged or not. And it comes back to what I said before, that while we're happy to make this general policy statement, as we did on Friday, we continue to expect firms and individuals to fully consider the risks of an entity being owned and controlled through doing your own research, and indeed through considering some of these illustrative examples that we have given, because our core objective here is to ensure that sanctions cannot be easily circumvented. And so this is an example of the kind of consideration that UK actors should be bearing in mind as they are looking at specific cases.
Okay, thank you very much. Now, just then turning to private bodies, we've talked about public bodies. The guidance from Friday says that the government does not presume that a private entity in Russia, or any jurisdiction for that matter, in which a public official is designated, is in itself sufficient evidence to demonstrate that the relevant official exercises control over that entity. I suspect this derives from what was said in the Mintz judgment by Lord Justice Flo. Now, can I just give you the specific example? I'm not going to ask you to comment on it, but I just wanted to, it seems to be relevant to the point. Obviously, the Russian government has a long history of what's described as sort of corporate raiding and taking control of entities. There was a report in the Financial Times just last Thursday in relation to the Russian subsidiary of Carlsberg. Two senior executives of the subsidiary, which is called Baltika Breweries, they were arrested by the Russian authorities. And the Financial Times report contained the following. It said that the raids come as Baltika Breweries has been placed under temporary management by Russian President Vladimir Putin, leaving Carlsberg with title to the shares, but no operational control over its subsidiary. So there it would seem, on the basis of that report, President Putin appears to have personally intervened in order to place that subsidiary under temporary management of the Russian state. So then coming back to your statement in your guidance from Friday, can you just then explain exactly what it is that you mean by this interaction between the public official and the private entity, and what sort of evidence, what constitutes sufficient evidence for the purposes of this test?
Sure, yeah, thank you, Michael. This was obviously an important element of the original statement that we put out following the Mintz judgment, and then with the benefit of the time that we've had, have sort of tweaked that wording for an initial statement in the guidance that was published on Friday. So I would encourage people to refer to what we published on Friday for the very latest. To be quite clear, a person should only be considered to exercise control over certain private entities where this can be supported by sufficient evidence. And I think it is important to proceed on a case-by-case basis on this issue. For the purposes of Regulation 7.4, we do, and in the particular case of President Putin, we do not consider that President Putin exercises indirect or de facto exercise control over all entities in the Russian economy merely by virtue of his occupation of the Russian presidency. I would be very loath to be drawn into how that may be interpreted in relation to specific cases, Michael, as you'll appreciate. But I think it is important to reiterate that overall policy position in relation to the Russian president. I think I would also come back to the point I made earlier that we do still expect firms and individuals to fully consider the risks of an entity being owned and controlled by conducting research and taking legal advice if unsure. But I think we're about as clear as we can be in that particular part of the guidance on our position in relation to President Putin specifically. Thank you.
All right, that's very helpful. Mike, can I just then come to you? We've heard what Daniel's had to say. We've seen the statement and the guidance document that's been put out by the government on Friday. How does this fit in your view with the wording of the regulations and overall legal certainty?
I think that a number of people listening to this webinar would be concerned about the current position from a legal certainty perspective, and probably in some respects none the wiser about how they can advise clients with any degree of confidence. And I know that both the Law Society and the Bar Council have expressed concerns about the position as regards a lack of certainty. I mean, it is obviously hugely important to know who is subject to sanctions. We're living in a world of strict liability and also potential criminal liability for sanctions breach. We now have a position where we have a number of different judges disagreeing with each other about the meaning of the regulations, obviously in very polite judicial terms. But we have one gloss put on the regulations by the High Court in Minsk, disagreement by the Court of Appeal, a very pragmatic subsequent approach, again, a different one taken by a High Court judge, government putting out guidance, and different lawyers reaching very different views on how one applies the control test, with what degree of due diligence. Does one simply look at public information? Should we always be commissioning reports from investigative bodies? This is an area of great subjectivity where information is hard to come by. So obviously the very welcome guidance is often always welcome in this field, is hugely comforting and welcome. But I wanted to raise one concern about how far does that really go? I mean, on a practical level, if one is concerned about enforcement risk, it could be said that given what has just been clarified and given what the guidance now says, it seems clear that the government wouldn't take enforcement action against anyone on the basis that President Putin controls all Russian companies. You need evidence of sort of de facto control. The problem is, though, this is not just about enforcement risk by the government. Courts and arbitrators need to know if a company they're dealing with is sanctioned or not. People have contractual obligations, contractual warranties. They need to know whether the counterparty they're dealing with clearly is sanctioned or not. Sanctions clauses, do they apply? And companies themselves need absolute clarity on whether they are sanctioned. And the problem is that although guidance is very welcome, OFSI and the FCDO are not the law in this area. That's the regulations and for the court to interpret. So there's only a limited extent to which government guidance can deal with the problem other than in a pragmatic enforcement comfort sense. And I think there is an additional problem about how one actually achieves clarity on this, because another common concern, I think, among those listening is how do we actually get a clear view on, if there is no clarity after digging and due diligence, how does one actually get a view from the government, who after all is imposing sanctions on entities, about whether those sanctions apply to them or not? So obviously the government says very often in response to a request for clarity, go and take legal advice. But I suspect that 99% of the lawyers listening to this would say we've tried to give legal advice. There just is insufficient clarity on how one applies the very broad test in the regulations. Sometimes, as we've heard, the government will take a view on a particular entity in public. So there are some statements in the reasons for listing about whether the government takes the view that a particular body is sanctioned or not. Sometimes the government takes a view in a more private context, either in response to a licensing application or, as Michael said, in a trade body meeting about a particular entity. And we've heard today that all the government intends to do is to put out the very public statements it's made giving guidance. But I have to say for myself, I don't understand why, if the government has reached a view about a particular entity, that shouldn't be made clear and transparent on a sanctions list so that everyone knows the position. That might also, if there were an amendment to the regulations, making the legal test clearer in line with what the government has intended it to mean, it may also have the very happy outcome that Ofsi might be less flooded with numerous requests from clarity from people asking them what the position is. So I'll leave it there, but I think the position is a bit of a mess.
Well, you've raised a whole list of legitimate concerns. I just want to then turn to Chloe. You've heard what's been said, Chloe. Can I just ask you, first of all, in terms of the financial services sector and banks in particular, why does the control test matter?
Thanks, Michael. And I want to start by thanking the FCDO, Daniel in particular, and Ofsi and Beth as well for coming to this webinar, because it really is a tricky issue for all of us that are working with the control test, which is not new. It's not new for banks. It's not new for lawyers. It is something that banks have had to understand and grapple with, both ownership and control, as long as I've been a sanctions lawyer. And for the most part, I think banks have managed to find and develop relatively sophisticated controls in order to manage the risk that is presented by this slightly ambiguous legal concept, which is worth mentioning is something that straddles a number of different jurisdictions. And as global financial institutions will find themselves often in a position when dealing with this particular test, it's not easy when you're looking across multiple layers of sanctions. But what is new is something that I think we have all had to grapple with over the past 18 to 24 months, is the reality of having to apply this test to live transactions and to client relationships in a way that we've never had to do before. And that's simply because of the unprecedented wave of sanctions that we've seen following Russia's invasion of Ukraine. And why does it matter? Well, first and foremost, because we all have to comply with sanctions. And if you get the test wrong, as Maya has rightly pointed out, there is a strict liability nature to any sanctions breaches involving this. But what's worth also remembering is that banks have to weigh in the balance, getting the test wrong and complying with sanctions, and the competing litigation and reputational risk that's associated with applying the control test. I think we've looked at a number of different examples, and one that I find illustrates the problem quite clearly. Now, it's not to do with a public official, but as Maya quite rightly points out, sometimes in the statement of reasons, you will find a little nugget which will help you understand whether or not you are applying the test correctly. If I take the designation of Roman Abramovich on the 10th of March, 2022, the UK government designated Abramovich, and in the statement of reasons as they were then on the 10th of March, we saw that Abramovich was supposedly exercising effective control of Evraz, given his significant shareholding. Now, we all looked at this knowing that on paper and public records, Abramovich held a 28 or 29% shareholding. So it begged the question, what does the UK government think? And what evidence does the UK government have when it comes to making that assessment of control? Now, for many, the decision was taken out of their hands because they held significant funds and there was a lot of publicity around the Abramovich designation. But for others, they didn't have necessarily that information to hand, and they were dealing with live transactions where they may have a counterparty, where they may not be able to access the level of information that they needed to be able to do that due diligence. But what was very interesting about this case, and I may say that amongst other financial institutions and through industry bodies, we approached the UK government on or around the 10th of March and said, what do you mean by this? Do you expect us to take a decision on control based on what's contained in the statement of reasons? Or can we say, for sake of argument, that because Abramovich only holds 29%, that in fact control isn't an issue here? What happened then on the 5th of May, 2022, so some 6 weeks later, was that the UK government designated Evraz. Now, it begs the question, why wasn't this done at the time if that information and evidence was available to the UK government?
So, maybe just following on from that, can I just returning specifically really to the interpretation that the financial sector is deploying now in relation to both the Mintz and the clarifying Litasco judgment. obviously, the industry won't have had time to absorb and reflect and digest the guidance from Friday. But what's your sense of how banks are interpreting what's been happening in the courts most recently?
I think it's caused a huge amount of nervousness. I think the Mint's judgment shook the industry, and there was a lot of discussion immediately after, which led to us applying pressure on the government. And in fairness to the FCDO, they did respond quickly. If we look at the response we've had in other areas, but we saw Litasco cause yet further tremors over the weekend. But what we have seen in response is a statement which has resulted in guidance, which has allowed us to derive some comfort. I mean, it's not completely settled the position as to how to apply this test and what it means when we're considering public officials who have been designated. But what I would say from the financial sector is that we're like oil tankers. We cannot shift our positions in the same way at the same speed as we may be able to if you're looking at one case on a case-by-case basis. What we have to look at is what controls do we have in place, and how do we develop things like enhanced due diligence in order to manage that risk over time. And there are many competing interests, as I've explained, and we can't have a knee-jerk response that addresses perhaps one court of appeal decision and forgets what else is going on globally in the context of control and also in ownership. And so the sorts of questions we would be asking ourselves is to whether or not the sanctioned party is involved in the day-to-day business of the company, what sort of influence can they have? And I think financial institutions have honed those sorts of questions and enhanced due diligence over a long period of time in order to manage that risk. And it won't just be one judgment that determines how we go about it. It has to be obviously a legislative position and the creation of some form of legal certainty over a period of time that will help us gain that stability that we need. But at the moment, certainly from my perspective, the market is a little bit unsettled as a result of those two judgments.
And do you think there is anything that anything further that the government can do that's going to give you and your market more comfort and clarity?
Of course, I think the government has already done something, and that's quite good given what we've seen over the past 24 months. But I think perhaps one needs to look at a legislative fix which defines the test in a more concrete and legally certain way. We also need to think about this not just in the context of Russia, bearing in mind that government officials, public officials that are operating in an influential way in the economy has its roots in regimes like Syria. So this isn't a new problem. This is something that the government and the industry has been grappling with. And I think the government needs to look long and hard at the legislative position across all of the sanctions regimes and ask itself what happened when the control test was transposed into UK law following the UK's exit from the European Union, and has this actually created more legal uncertainty or has settled the market? And in my view, there is certainly an opportunity now. Perhaps there could be a look back as to what has happened and how financial institutions have managed this risk, and give not just guidance, but legal certainty through an amendment to those regimes.
Thank you very much, Chloe. I think you raise a very important point, which is obviously Mints and Litasco relate to the Russia regime, but the guidance that was issued is much broader than that. And there's a read across, obviously, to multiple other jurisdictions that are subject to sanctions. Beth, can I just turn to you then and just look at OFSI's position? First of all, we've heard about the uncertainty. In uncertain times, perhaps we can get some comfort from you. So I'm going to implore you and see if you'll give it to me. So we've heard what Daniel's had to say. We've read the guidance. So can those listening to the webinar, can they assume that if they're dealing with a Russian public entity that has not been specifically designated, despite the public official who seems to be in charge of that entity being designated, that if that entity is treated as not being sanctioned, subsequently turns out that that's the wrong interpretation, that OFSI would not take enforcement action?
Hi, Michael. So we need to consider everything on a case-by-case basis and maintain vigilance. So I think the key message that I would be putting out to listeners is that due diligence remains as important as ever as a result of this. Now, Ofsted is not looking to penalise good faith acting here, and we will be really taking into account what due diligence was undertaken. But essentially, the assumption that you don't need to make any other queries or undertake any other investigation and take legal advice, you always need to follow that due diligence. That is the key message that I'd just like to reiterate. As I said, we understand the challenge that this presents to industry, and we're undertaking, I'm delighted to hear that you found the guidance useful and helpful, but it remains every organisation's responsibility to undertake that due diligence for themselves and to take a determination based on their risk appetite and based on legal advice that you seek. So we set that out in our enforcement and monetary penalty guidance as well. And as I said, we're not going after good faith actors that can set out when we undertake any enforcement activity. We'll be looking to see what records have been kept. We'll be looking to see what questions have been asked. And that's allowed each organisation to make that determination. But that's the key thing. You do need to take those questions and you do need to undertake that due diligence.
Okay, so if we sort of turn to the regulation, and particularly sort of Regulation 7.4, and try to analyze that in line with your guidance. So the control test, I think a lot of people are very interested in this and how it ought to be interpreted. So just boiling down a little bit to specifics, when do you think it's reasonable to expect that a designated person could achieve the result that the affairs of a company are conducted in accordance with his or her wishes, if he chooses to, in most cases or in significant respects, by whatever means, directly or indirectly? That's the kind of wording of Regulation 4. So when is it reasonable to expect that?
Well, as Daniel set out, the Foreign Office does not generally consider that designated public officials will exercise control over a public body in which they hold a leadership function such that the affairs of that public body should be considered to be conducted in accordance with the wishes of that individual. And that's what Regulation 7.4 says. With that said, it's ultimately, of course, for the courts to make the determination about whether or not any of the ownership or control criteria are set. And if they are, I think the language we use is deliberately broad. We're looking to make sure that financial sanctions cannot be easily circumvented, but we really appreciate that that's a challenge. And we're looking for you to undertake those questions, as we said, to conduct your own research and request further information from entities, because ultimately it is each organisation's responsibility to familiarise yourselves with the relevant sanctions legislation. But as I said, ultimately this will be a decision for the courts to take, and it's reasonable to expect the courts would also take the guidance that the government has put out into consideration as well.
I appreciate that the wording of it is overly broad. It's very broad. So sometimes breadth can be sacrificed on the altar of clarity. So just on that, or just on specific phrases, because specific phrases in Regulation 7.4 are extraordinarily important. We spend a lot of time cogitating on how they ought to be interpreted. So where, for example, it says that a person could achieve the results of a company to make sure they're conducted in accordance with that person's wishes in significant respects, just that particular phrase, can you help us at all with what that means? Can you give us any guidance on that?
So I think significant is going to be highly dependent on the entity in question and the circumstances. I think that's the really key point that I keep reiterating, is it's a case-by-case basis. We need to be looking at what the circumstances are when for each transaction or undertaking that you're considering. But where we might be thinking about public bodies, as we say in our guidance, one of the things that we're looking about, for example, is whether the designated person derives a significant personal benefit from payments to that public body. So an example of a payment such that they amount to a payment to the person. So that's one example, but we're just giving illustrative examples and we can't provide an exhaustive list, I'm afraid.
I don't know whether the guidance that came out on Friday was able to take into account the comments that were made by Ms. Justice Foxton in the Tasco, which was only a few days before. But in that case, he seemed very reasonably to be suggesting that the wording of "if a person chooses to" means if that person chooses to now. So at the moment, it's a present time scenario, rather than some possible ability to do the same thing at some point in the future. Do you think that that's right? And is there any possibility that the guidance that was issued might be tailored, sort of take into account Mr. Justice Foxton's comments?
I mean, we're still considering those comments at the moment. I think what I would say in respect of the guidance and what we set out there is it's really important to continue to look at our assessments of ownership and control, because the circumstances can change. And that's a key point that I just want to reiterate, that an assessment has to be carried out on an ongoing basis, really, to see whether, I think some of the questions that we might want to think about, or that organisations will want to think about, is what level of control can a person exert now, but also what steps would they need to take to change the way that the company is run? What level of control could they reasonably expect to exercise after those steps have been taken? So those are some of the lines of inquiry that you can undertake, but it's really going to be very case specific. And any real life case would require more investigation and analysis of the facts. I think we can't make sweeping statements and sweeping assumptions or assertions, I'm afraid.
Okay, well, obviously it does create huge issues for us. We as lawyers, we try to do our very best in order to provide the right legal advice in difficult and complex circumstances. Is there any Ofsi guidance that could be provided when parties seek advice from Ofsi about whether an entity is owned or controlled, having done, the level of work that you would expect rather of us from a due diligence KYC perspective?
So, I mean, our position's not changed. I'm sure many listeners have heard me say this before, that Ofsi does not make determinations about ownership and control. We just can't provide on a matter of course on every circumstance. Carrying out appropriate due diligence is the important responsibility of businesses and organisations. And also, the view that Ofsi takes is not necessarily the view that the court would take. It's not determinative of law. So that's an important point to bear in mind as well. I think when we make licensing decisions, if we receive a license application, then we'll be considering that on a case-by-case basis, but we will have already expected the applicant to make a determination about ownership and control before they've submitted the license application. And ultimately, we can't outsource to an organisation what their risk appetite may be. Once you've undertaken your due diligence and your considerations, then it remains a question for each organisation to consider within the realms of their risk appetite how they wish to proceed once they've taken their considerations into account. So we're not under, as you know as well, we're not under a statutory duty to make determinations, but we did publish some guidance in March, and we're continuing to have conversations like this on numerous levels to continue talking to industry and to provide further clarification where we can.
Okay, thank you very much for that, Beth. Daniel, can I then just turn to you? At the end of the statement that was issued by the FCDO after the Mintz judgment, you said that you were exploring options as to what further actions could be taken. Are we to assume that what that meant was the issuing of the guidance that came out on Friday, or is there any appetite? Because you've heard on this call already this morning comments being made about the regulations, and that being at the sort of heart and soul of some of the problems that have been created. Is there any appetite to actually have a fresh look at the regulations and see if there's anything that can be done with the wording of the regulations to achieve both your objective, but also to provide sort of clarity and certainty to the position, and perhaps take on board some of the comments that have been made by the judiciary?
Thanks, Michael. Well, obviously, we always do, and we do continue to monitor feedback and look very carefully at concerns and questions that are raised with us by those involved in these issues. And you're right that in this particular case, the, as it were, sort of further step that we decided it was appropriate to take was to issue the refreshed guidance that came out on Friday. I think, as you also pointed out earlier on, Michael, this language, of course, appears across numerous sanctions regimes, although the Russia case is the one that is perhaps most engaged at the moment. It features in numerous sanctions regimes. So we do need to look very carefully at the implications across our sanctions framework, not only in relation to Russia. So I'm simply not in a position today to make any sort of further commitment to what we may do. But the refreshed guidance was the kind of thing that we're referring to in that statement in terms of the further step that we'd be prepared to take in order to give that additional clarification that Beth was talking about.
Okay, all right, that's very helpful. Thank you very much. I'm not IT savvy enough to be able to talk to you all on this and also check what's coming in from questions in the Q&A box. Maya, I know you've been keeping a little eye on it. Are there any particular questions that you'd like to draw the attention of our speakers to?
There are lots. I'm just going to try to sort of group issues rather than firing lots of different questions. But one of the themes of the questions that's coming through is about the clarification in the guidance about the purpose of the control test from a government perspective, namely to avoid circumvention. Because the issue that a number of the questions raise is, if that is right, why not take the US approach, which is not to have a control test at all, but to say sanctions apply where an entity is owned by a designated person. Control becomes relevant in other contexts, for example, in relation to the facilitation offence. But if circumvention is the issue, why not remove references to control, which would make everyone's life easier, not least the government, and leave the circumvention offence, which is very squarely in the regulations in Regulation 19, and the concept of ownership. Because the emphasis would then be on the government to designate individuals and their networks of companies where appropriate, rather than, as it were, as has become the case in the UK, having the burden on the private sector in circumstances in which the private sector seems very unclear on how to apply the test.
Michael, shall we have a go at answering that?
That would be wonderful.
Thank you. I mean, I don't want to comment too far on other sort of jurisdictions' approaches to these things, other than to say that, of course, we've worked absolutely hand in glove with the US, with the European Union, with other members of the, as it were, sanctions coalition over the last 18 months in the waves of sanctions that we've been imposing against Russia, also on our broader approach towards sanctions. And we held the first round of our strategic sanctions dialogue with the US, which is a cross-government dialogue held at senior official level in the summer as well. So we have very, very close engagement with the US as well as other partners on all of this. I think on the specific issue, I think it comes back to really what Beth and I were both saying, really, which is that the purpose of having this control test in here is to minimise the chances of sanctions circumvention. And in the instances that we have been considering, the role of the private sector to undertake that due diligence, as it were, at the point of transaction is extremely important. Now, the US has chosen to go in the path that they have chosen, you know, and you would need to ask them for all of that. But we do consider that this is an appropriate way in which we can ensure that sanctions circumvention, as far as possible, does not take place by asking the private sector to undertake that due diligence as they approach a specific transaction or undertaking, rather than, as it were, sort of in the abstract. So that's why we have the test as we do. Beth, anything?
I mean, I would echo that entirely, Daniel, and just to reiterate that OFSI and OFAC in the US work really closely together. We have an enhanced partnership with them. I have a member of my team now that's on secondment from OFAC, and we're looking to reciprocate that. So we're working really closely with our US partners and with EU's member states as well to look at ways in which this has been interpreted. But exactly as Daniel says, we are really think that this is an appropriate level of additional due diligence that companies should undertake to really mitigate that risk of circumvention.
Could I just ask,
Michael, may I, sorry, Michael, can I just come in there, please? Because I sort of, I think Liz Rosenberg said that financial institutions are at the coalface. They are at the front line of circumvention. And I would agree in part with that comment, but I'm not sure that the control test helps financial institutions identify and prevent circumvention. I think, in fact, it creates a huge amount of uncertainty, and we have to devote a lot of resources unnecessarily to that level of due diligence that we would otherwise not have to be engaged in if the test of ownership, which is a very well-established test in the US, was applied more consistently in the UK. And I think it's something that we have lobbied for both in the US and obviously you've said have got your relationships with OFAC, but also in the EU as well. And we've seen the EU develop an aggregated ownership test over the past year and a half. And whilst that has not been applied across all member states, it's certainly helpful for us when we are dealing with issues like circumvention. And I'm not convinced that the control test helps us there. I think actually the thing that would help us most is to have designations where there is evidence to designate. And that's where we really feel that the UK falls foul of its obligations on that front and makes it much harder for financial institutions to comply, because by not designating and relying on a very vague test like control means that more resources have to be pulled into identifying whether or not a public official or another individual controls a particular entity. And I think that could be cleared up quite easily if, in fact, the UK chose to designate where there was sufficient evidence. Because if there is evidence for a company, there must also be evidence for the government to be able to substantiate those listing reasons and designate where possible.
Thank you very much, Chloe. Can I just ask, there's been a few questions about due diligence and the due diligence that is required in particular circumstances. And I don't want to predict what you're necessarily going to say, but I suspect it might be everything has to be done on a case-by-case basis. But we've seen situations where there are wide variations on the level of due diligence that gets done. So, for example, if you're trying to make a determination about whether a company that is based in Russia is controlled, ownership is relatively straightforward, I say straightforward, but control is much more difficult, it's much more nuanced. Would, for example, OFSI deem it to be sufficient to do due diligence on publicly available sources in order to reach a particular conclusion? Or would you expect, in the circumstances, a law firm or a client to instruct, for example, a private, credible investigative firm with experience, know-how, and knowledge of the Russian market in order to explore and examine the relationships between the senior people in the company to make sure there were no shadow directors or control that's indirect around the back, et cetera, et cetera? Is that the sort of KYC standard that OFSI would expect, just so we have a sort of vague idea?
So obviously it's trying not to be overtly prescriptive by saying what every firm or organisation, exactly what the steps they must take, because we know that we are working with a wide range of organisations across a number of industries. So I think the key point to reiterate is it is a case-by-case basis, and it is also up to the risk appetite of each organisation as well to take that determination, to consider, bearing in mind the facts, bearing in mind the regulation and their obligations, to consider how much investigation and legal advice they wish to take. So we're not looking to take those decisions on behalf of the private sector in that sense. So yeah, I'm afraid it is a case-by-case basis.
Could I just come in and just ask again another of the sort of themes that's coming through? So you have certainly made clear here and before today that OFSI doesn't make determinations itself on ownership or control. So I suppose the first question on that is for us to understand why that is. Obviously, it's the government imposing sanctions on bodies. So why is it that the government won't say which bodies it's imposing sanctions on, is question one. And then a related question is, obviously OFSI does sometimes make a determination about whether a company is owned by a designated person, sometimes in the context of a license application, for example, sometimes in the context of deciding whether a breach of sanctions has occurred. But where it makes those determinations, those are not made public. Michael also gave the example of a determination that was made in a trade body meeting, but again, wasn't made public. So we just wanted to understand first why you won't make determinations, but secondly, why you won't make public determinations that you've already made privately, given the need for transparency as well as legal certainty in this area.
As I said, it does remain our position that OFSI doesn't make those determinations, and because ultimately it's a matter for the courts to make those determinations ultimately. So that's one of our positions. If we're undertaking a license application, then it will be a case-by-case basis, and obviously we'll be looking at the application and the information that is presented to us at that point. And we would also have expected the applicant to be making a consideration at that point when they put the application forward. But it remains the policy at the moment that we do not make the determinations public.
Could I just ask a question? This is probably more to Daniel than it is to Beth, but it's to both of you really. I'm not expecting a platinum edged guarantee, but we have seen in the past that it benefits, I think, the government and the quality of the guidance that comes out, that there is outreach to the particular sectors who might be impacted. And sometimes when there isn't outreach, we get into unnecessary problems. Would there be an appetite, if there is any potential for further guidance or even perhaps changing the regulations in some way, would there be any appetite for some level of engagement with those sectors that may be affected before any change was absolutely finalized?
Thanks, Michael. I mean, I would definitely endorse your earlier point, and in fact, I think the point that Maya and Chloe both made as well, which is that financial institutions and all of those on this call are absolutely at the forefront of effective sanctions implementation. And so from that point of view, the sort of engagement which we've, I think between us have really expanded very significantly over the last 18 months with various different elements of the private sector has been really critical to helping us implement the kind of sanctions that we've imposed over the last 18 months as effectively as we can. We're certainly very open, we're very keen to engage with the private sector as we're taking this sanctions effort forward as well. I think that will remain an important priority. We also, as you will appreciate, need to retain the ability as government to do our policy thinking, as it were, with a certain level of confidence, and also to work very closely with our international partners on that kind of confidential basis as well. So it's a sort of yes and no. We are absolutely committed to the sort of engagement that you were talking about. At the same time, you would appreciate there will be areas where we will need to sort of lock our doors and get on with the work, and then obviously be very clear in the decisions that our ministers have taken as soon as we possibly can. Thanks.
All right, thank you very much. Are there any closing comments, Maya, Chloe?
I'm not going to make closing comments, but I did just want to see whether there was any appetite to answer one sort of final theme in the questions. I guess one is, maybe this is really two questions, but one is, why is the risk appetite of an individual organization considering ownership or control relevant to the determination of to the issue of how much due diligence should be done, given that we're in a strict liability situation? That seems odd, that it should depend how risky an organization wants to be, but maybe I misunderstood you. But I suppose the final question would be, if OFSI won't make public determinations it's made about whether a particular entity is controlled, and won't have a mechanism for people seeking clarity on particular entities, a couple of the questions are about, would you consider more US style Q&A, frequently asked questions, answers on ownership and control? Because there are a number of answers to questions I think people find very useful in the US, which are not, is X designated. but more, you know, the example that's been given is OFAC says if a governing official with a leadership role is blocked under certain regulations, is the governing institution they lead considered to be blocked as well? And OFAC says very clearly no. When a designated individual has a leadership role in a governing institution, the governing institution itself is not considered blocked. That kind of thing wouldn't commit you in relation to particular entities, but I think people would find it enormously useful to have that kind of Q&A.
Thanks, Maya. There was a couple of questions there, so I'll try and get to them, and then Daniel, maybe you can come in at the end as well. So I think just on the point about Q&A, I think that is something that we're looking at. As I said, we're working really closely with our US colleagues about the way in which we can put further information out. So that's something we can think about more. On ownership control, one of the other points that I should have made about whether Ofsted can make a determination or not was also the fact about that being a moment in time. So as I said, that's like if we were to make a determination based on the information provided in a license application, that would be at that point, but obviously control can change, circumstances can change, as we said. So that's one important element of how helpful or not our determinations may or may not be, particularly, as I say, they will not be determinative of law, and it will be for courts to make that determination as well. So, and I think on the point about due diligence, it's more, that's kind of mitigating. Those are some of the mitigating circumstances that Ofsted will be taking into account if we're looking at an enforcement investigation. As I said, we're not looking to penalise, or we're not looking to go after those that are acting in good faith and that have clearly documented what steps have been taken and how far they have chosen to pursue those. That's a key element that we would be considering on a case-by-case basis under any investigation that Ofsted was pursuing. And Dan, did you want to come in on?
Yeah, thank you, because I know we're out of time, Michael. I just wanted to point out that obviously the sort of questions that you've had understandably have ranged across a number of different ownership and control issues, but I just wanted to come back to, as it were, the sort of core objective of the guidance we put out on Friday and the webinar today, which is the particular issues relating to public bodies. And you know, to recognise, as we said at the start, that we did consider that there are particular risks when it comes to public bodies becoming subject to sanctions, and that where there's that uncertainty, this can lead to some unintended impacts, such as people considering that they're unable to pay taxes that they're legally obliged to pay, for example. So I would just come back to the sort of the core purpose, as it were, of the guidance on Friday and the webinar today, that we have looked to provide that additional clarification, particularly in relation to public bodies and in respect to the Mint's judgment in relation to the position of President Putin personally as well. So I do hope that has been helpful, but we are very conscious that these are very complex, wide-ranging issues. But in this particular area, at least, we hope that we provided some additional clarification. Thank you.
You
Michael.
Yes, Chloe.
Sorry. Yeah, just very quickly, just to add that I think the guidance is welcome, but in absence of more from the government on this very tricky issue, we're going to find ourselves probably repeating a webinar like this as we see judicial decisions mess with the concept of control in a way that is quite unhelpful for those that are seeking to apply it. So I think more from the government is certainly needed here.
Well, I'd just like to follow up with that, just to say thank you very much indeed for all of you for taking part in this. In particular, thanks to you both, Beth and Daniel, giving us the government's perspective. For those of you who feel a bit frustrated that your questions didn't get answered, what we will do is we will group them in themes, and we will send them through to the government. There's no commitment to answer them, but it will help to perhaps give you some sense of what the issues are and what the concerns are from practitioners across the broad sanctions landscape. So thank you all very much for listening. And again, thank you all for participating. And we will do this again at some point in the future.
Thank you.
Thank you.
Thank
Thank
you.
you.